active. Yesterday we were tired, this morning we were still sleeping. So let's keep each other awake as usual by interrupting at any given moment. You hear me well? Back there? Right. Okay, so try to speak like this. Okay, so let's see. WIPO experience and resolution service provider. Good morning. No, nice to meet you. Nice to meet you. So we got pretty much everyone here. The WIPO Center is, as you know, the center that does a larger number of cases, about 55%, we'll see the statistics in a minute. And it is composed by 24 nationalities with 26 languages spoken. They have very experienced senior legal staff and a number of case managers. It's funny that I'm going to congresses and meeting people, and I always see generation of case managers moving on to professions and working law firms like yours. And it's nice to get in touch with them. It's basically a 2 years or 1 year kind of experience the case manager have, while the senior staff is more, of course, stable in Geneva. Young professionals interested in handling maybe cases, may have this experience of being exposed to an in-depth analysis of these cases by handling them in WIPO. The case secretariat is very efficient. I have experience, as I mentioned, in most of the dispute resolution providers, and WIPO is certainly the most efficient one. They cooperate with you, they help you out if you need anything. Excellent IT support as well. The platforms that we will see is made available free of charge by WIPO. It's a very good tool for lawyers working in this field. As for ours, this is the last picture, and this is Eric with us, my dear friend, and now director of the Arbitration Center. And when I met him the first time in 1997, how old some of you were not born there, but he was in charge of the dispute arbitration on domain names, which was just recently established. WIPO panelists, it's us. It's a bunch of crazy people who decided to devote some of their time, mostly on a pro bono basis, to the developing on the jurisprudence in this field. And thus, it's a group of about 500, as I mentioned. You find all the information about ourselves on the website. And the representation is rather wide. We are from 57 countries across all the continent. And you will see in a minute, that's why, because of this, the reason is because the statistics show that the number of infringers, the respondents, are increasing worldwide. So different geographic areas are involved, and the language of agreement, as you know perfectly, because we were dreaming about that last night, changes according to the place where the registration agreement is made or the applicable language. So this is about us, and there is a list of our curricula online, divided by country and by the national. So some statistics. This is some of the graphs that show the evolution of the decision in the last years, actually from the beginning. This is a statistic which was presented in October, actually in November, when we did our advanced course. So I apologize I did not upgrade it, but this is basically was meant as a figure. So this year was higher than 2014. The record was 2012 with 2,884 cases filed with WIPO. This is all statistics with WIPO, not considering the other NAF and additional providers, as I mentioned yesterday. But certainly is a record year. The reason why it was decreasing is possibly to be found in the launch of the new generic of the domains, which was basically using a lot of the resources that IP attorneys and IP owners had to dedicate to this budget, but it went up again and is increasing. The idea to have 3 providers, actually 4, is reflected in the slide. The majority of the cases, as mentioned, about 55%, is filed with WIPO, 40% with the National Arbitration Forum, and the rest amongst the 2 other dispute resolution providers, which are, just supposed to ask you that they are the Asian and the Thai. They are based in Czech Republic, in Prague. Termination, This is actually is interesting data because, as I mentioned yesterday, the 19% of the file of the cases filed with WIPO reach a settlement agreement, therefore, as either terminated or settled. And this is significant kind of statistics because it show that, as mentioned yesterday, sometimes you need that you should wake up now. The statistics show that only when you file a UDP, probably you manage to convince the domain name holder hiding behind third-party companies or shield company to show up and say, well, okay, I'm sorry, I will register this domain name in that thing. Usually, and we'll see later on, if you manage to get the dedicated citizen's letter, you get the same results, but filing UDP is certainly a good tool to get them coming out from the shields they hide behind it and to get a settlement. So in that case, as I mentioned yesterday, if you do settle or terminate the case before the panel is appointed, you get 1,000 of the $1,500 that you pay back. And basically, in this 30 years, WIPO managed to return to the complainant $5 million US. Good savings. And that's another good reason, I'm somehow impartial, but of course, to recommend WIPO, not only because they handle the cases well, but if you do manage to settle, which happens close to the 20% of the cases, you get $1,000 back, of course, will return to your client, and they'll be even happier to entrust another case with you. What about then the 90% of cases is really significant. The filing by industry, as you see, statistics are interesting as well, because you have about, let's say, I cannot see it there, but 11% retail, 11% fashion, and 10% banking and finance. This shows clearly the trend of having a lot of phishing, we discussed about yesterday, in banking and finance, reflected as well in domain names, and of course, fashion and retail in general, which means sales online, is something that is very relevant. So, the rest, of course, is going down, but you see as relevant automobiles, heavy industry machineries, internet and IT, pharmaceuticals are all ranging about between 5 and 7%. And the statistics show confirm this year as well. So retail, fashion, and banking are still the top filing industries. As I mentioned, I get WIPO parties from all over the world. Actually, last year was 107 countries. Overall was 177 countries. So in all the years, they have basically received complaints from all over the world. Complainant filing, in all the years statistics, is interesting to see that the top complainants are United States, are based in the United States, the second one in France, and third one was United Kingdom. While last year statistics show that Germany was overcoming the United Kingdom, probably because of the industry, they have the automobiles and fashion. But that's as well as an interesting statistics to see that between 35 and 30% of the cases, complainant are based in the United States. Italy is there, 81. I didn't name any of those, but it was on this level basically the same. We're going down a little bit. Egypt is not there because, of course, you don't have this procedure available here yet. Maybe in the future. All years filing. So the respondents were basically based as well in the United States. So interesting to see, but of course, as expected, the second country where the most respondents are based is China. Spain and United Kingdom, actually United Kingdom and Spain are following. The most recent statistics show pretty much the same organization of the top level. So United States, China, United Kingdom, and then Australia was coming up. Probably because a lot of respondents use privacy shield company based in Australia. As you know, we file a UDP against the respondent, which is shown in the WHOIS data. So the WHOIS data is reflecting, or is supposed to be reflecting, the real data of the owner. So when you file the application for a domain name, you should declare your real data. Of course, most of the parties do not do it. They use either invented terms like James Bond, we seen yesterday, because there's no any requirement of submit, for instance, evidence of nationality or residence for the generic ones. While it's requested in any country code, it is not requested for account.com. Therefore, first come first served, even if you are James Bond on Mickey Mouse. Many companies, though, use Shield company. It has a company created for making registration, which sometimes, of course, has a good rationale. Say you don't want to be exposed to a lot of spam emails you receive, because if you declare your real email address, you get a lot of spam. They are public data. B, if you have sensitive website or sensitive domain names you want to sort of not disclose to the people, well, those are some of the cases in which you could use validate Shield. But the overall majority of the companies using Shield's company is basically to hide a real identity behind the screen, and many of them are based in Australia. Language of the procedure, as you see again here, you have English as the most important language, French was the third one, and Spanish was the second. Then German, Dutch, Chinese was only coming 1, 2, 3, 4, 6. This is overall, and this year, guess what? Chinese came to the third language. So that's why they had to hire a lot of case managers in Chinese, and we have to use a lot of translators in Chinese. If you want to pick a language to study, probably if you're in this field, Chinese is the option. Yes, French is still there, German, Italian is not even in, as just on the very bottom of our below here. Not this is. Okay, outcome of cases. We've seen yesterday that the vast majority of the file complaint ends up in a transfer. Why is that? Why do you think we have such a high percentage of transfer? 86%. It's a lot, isn't it? Why is that? Any ideas? Workshop? I ask questions. Come on, let's come up with some brilliant ideas. Brilliant lawyers here. Why is that such a high percentage of transfer out of a case file in Italy? Yes? No, sorry. Yes.
Actually, the rules are clear.
Right.
So no one is going to claim the domain name unless he pays 200% of the law.
That's exactly the point. So no one but 12%. Right? So this is pretty much the average of the people trying to. And this is the overall statistics. This is even more interesting because it changes a lot. So we have 86% overall transfer, and 88 were the single member panel. But you recall yesterday that we have the option to have 3. So what do you think would be the statistics for the 3-member panel? Would we allow to say or different? 84? Any guess? How much is going to be this statistics for a 3-member panel? You recall the case in which you have 0.3 panels, when you have different cases, or when a respondent wants to reply, you appoint basically a panel 3. You pay the additional 2,000 if you're a respondent, unless you decide to go with the 4,000 as a complainant in the different cases. In many occasions, the respondent says, hey, wait a minute, I have a legitimate right. Let's discuss about it. I want to have a panel as well. I want to have in the panel there was someone who can defend my reason. And in that case, I pay $2,000, you pay additional 500, you're a complainant, and we talk about it. So what do you think about it?
88.
Would be the same? 88, so we take 3 bits. 88, person in the back, who is offering less or more? How much?
Less than 86, but it depends on the number of single members.
No, let's set the rules clear. Now we're talking about a guess if the pile of 3 will have a different outcome as an overall percentage, or be pretty much on the same level of percentage. So this is going to be true.
The combined is less than the intrusive.
Yeah, of course. Let's say, given all the numbers of only the 3-member panels, what would be the outcome? Would be about the same, or would be different? What do you think? Different. How much?
50.
50%, 50-50 split?
Yeah.
Any other idea? Workshop, I asked, but that's a very good guess. Actually, your colleague is very brilliant. Denied 46, transfer 52. Is striking difference, isn't it? What is the rationale of it? Three-member panel, interest of respondents. So, on the overall cases, when we have three-member panels, you get a much different outcome, which is very good, because it shows the system works. It shows that it has warranties for respondents, which in good faith use the meaning. So the system is effective to this extent.
Actually,
Yes.
if we combine single member panel with three-member panel, it will never get.
Of course, no, but this is a statistics only for the three-member panel. So the overall, as you see, it doesn't impact on the overall decision because the number of the three-member panels is a minority. But amongst those, and only those, so we have a three-member panel appointed, the outcome is very different. It shows that the case of the respondent can be there. It shows that the system is balanced. It's not over-favoring the complainant. It's about 50-50 split. So basically, when the respondents show up and say, hey, wait a minute, these are my rights, these are my legitimate interests. I was in good faith registered this domain name. You are wrong. You are doing a case of reverse domain name hijacking. You are trying to threaten me. So in those cases, the outcome of the decision is 50-50. So the system works. Yes?
Isn't it shown that many clients didn't know the difference between lawyers and arbitrators?
Well,
I think arbitrators should be impartial, maybe, and expert.
well, actually, I wouldn't blame it on the client, because the client, as you know, is always right. The advisor as well, I wouldn't blame it on the advisor. I would blame it more in the system, which is basically allowing the respondent to present its case and say, well, these are my reasons. Notwithstanding the fact that they present the case, in 50% of the cases, 52% is still a transfer. So basically, it is not there. Just by the fact of showing up, the respondents by definition is right. But it's significant in my view that such a large number of denied decisions are coming in the three-member panels, which means the discussion amongst the panel is fair and the reasoning provided by the respondent is significant. So I wouldn't blame it too much on that. And the arbitrator has to be impartial. We have to sign a declaration whereby we declare that we don't have anything to do with any of the parties involved. So that's why I have to deny a lot of cases, because I not to take a lot of cases, because of course I know most of the pirates operating in this field nowadays, unfortunately. Having been working in this field for 15 years, and they take a target to be, the professional ones tend to be a group of limited people. But that's part of the fairness of the system. If you have, you know the counterparty, you cannot take the decision, because it can be maybe impacting your impartiality. So, with this in mind, the system works. Yes?
Two questions. One, who decides on whether the panel would be one arbitrator or one single panel or three members panel?
Well, it is either the complainant himself, if they wish to file the case with the three-member panels. So I can decide, well, this is a case of free speech. I was discussing that yesterday. I'm not sure that if I have bad luck and I get an American lawyer discussing this, I will probably lose my complaint. So it is a very complex situation. I want to make sure that the panelist is not simply distracted or having a lot of work to do and simply take a decision with the left hand without thinking properly about my case, without reading all the evidence I have provided. With the three-members panel, I would have a much better percentage of success. At least I would have a better percentage of assurance that the fact that amongst the three of them, someone will get the difficulties of the case and will examine it in depth. While, as well, the respondent can decide. The respondent receiving the complaint after it gets notified to him for her, may decide, well, come on, this is BS, this is not correct. What the complainant is stating is simply an attempt to threaten me. So in that case, he or she decides to have a three-member panel by stating, well, I'm ready to pay the $2,000 difference, because the fee overall for the three-member panels is $4,000. So when you file as a complainant and you want to have one single panelist, you pay $1,500. If the respondent decides to have the three-member panels, he or she pays $2,000, and then you're supposed to pay additional $5,000. So in this case, both parties both have the rights to do it.
Okay, my second question is,
Yes.
so from this chart, or these charts,
Yep.
is it true that it's, I mean, in most of the cases, the complainer would go with a single member panel because apparently results are, you know, would be in his favor, in his favor?
Absolutely. In the vast majority of the cases, I mean vast, the complainant opts for one. Because again, as mentioned in the discussion before, it's somehow a clear-cut procedure. You have this fantastic requisites which are, come on, first one. I know it's early.
Lawyer.
No, you have to have a trademark registration. The second requisite of the EDP is legitimate interest. So the respondent should not have a legitimate interest or a trademark right. And the third one is, shall it be more about that? Bad faith at the time of registration and in the subsequent use, conjuncting requirement. Yes.
Okay, both the respondent and the plaintiff, each one insisted that a party owns a single member panel and the other one owns the three-member panel. And they disagree
Well,
on this.
the three-member panels wins, because of course, if you are the complainant, you can say, I want to have a single-member panel, right? But if then the respondent wants a three-member panel, you cannot say, no, I don't want it anymore. Theoretically, you can withdraw. You complain, but it doesn't happen. You
It's
simply
the
show-
respondent say yes or choose.
Yes, in that case, it's a respondent choice. Unless you, as I mentioned before, decide as a complainant to go for a three-member panels, and then you pay $4,000. The respondent doesn't have to pay anything. It's your decision. It's my choice to be on the safe side, let's say. But when you have a three-member panels with the decision of the respondent, meaning the respondent asking for it, he pays $2,000, and you're obliged to pay $500. If you don't pay, the loser pays. Yes.
So, apart from the numbers, who gets to choose the panelists?
Okay, as I mentioned yesterday, the selection of the panelists is run by the dispute resolution provider, that's WIPO, and the rules are the one that is the WIPO selecting the panel if it is a single member panel. And again, the selection process, for instance, in NAF is, let's say, alphabetical order, and they go like this, in circles. At WIPO is a bit different, because of course when you select the panelist, you have to consider different options. Even the language skills. If the next one in line does not speak Spanish, and it's complained to be rendered in Spanish, you cannot appoint this. If the complex issues are there, if it is very delicate matters, they tend to select the more experienced panelists, the one that tend to be paying attention to what they do, right? They want that you not make too many wrong decisions or terrible mistakes, and basically it's off the records, but they have a sort of ranking amongst us as panelists, and they tend to give, as I mentioned yesterday, the bad cases to the more senior ones having experience. So unfortunately, I got a lot of bad cases besides being complex ones. But it's part of the fun of being doing this kind of work and being involved in this field. But usually the appointment is not like strictly random, but it's dedicated to the complex, a number of factors. They keep track of what, of course they keep track as well of the incompatibility. So if they know that I'm assisting Gucci, Ferrari, Maserati, they don't entrust with me, a complaint may be filed by another company. Or if I assisted someone in the past and or I'm approaching someone, I'm declaring, of course, if I get appointed, but they know it before, because the file the complaint I'm filing, and they don't appoint me, of course, in the case in which a related company, for instance, a part of the same group, is involved. Yes.
So let's say the registration agreement was in Arabic,
Yep.
and we are looking for a three-member panel.
Yep.
That means that all three members will be
We'll have to speak.
speak the language. So most probably they will be either related to the region or yeah.
Absolutely, and sometimes this creates a problem, and sure enough, I got to get through it. For instance, there was a case in which the Romanian, it was longer, Romanian roster of panels, or three of them, and all of them were conflicted out. So I received a call from WIPO and said, well, look at, as Romanian is a language close to Latin, Latin is a language close to Italian, and you study Latin in school. Would you mind to take a decision in Romania? Well, Romanian. I said, well, I won't draft the decision in Romanian, but I can certainly make an effort to read the documents in Romanian. So actually, the husband of the sister of my wife is Romanian, is a doctor based in Germany, so I had it and his family involved in this situation. But this is an exception. Because 2 days ago, I rendered a decision in a three-members panel about a case in Turkey, where again there was a similar problem, but I was one of the members of three-member panel, so kindly both the president and the other panelists translated most of the documents to me, and we even decided to render the decision in English, even though the case was handled in Turkish, and everything was in Turkish. We can decide, because the first English is known by the party, to apply only for the language, not officially, but the language of the decision in English, so I could participate in this. But this again is an exception to the rule. If the language is involved, you have to have the panelists in capacity to read all the documents. Good. I like these interactive kind of speeches. Thank you very much. So, country code. Let's go over the country code. We're talking about generic ones. As of June 2015, about 136 million of domain names over the 298 million registration were country code. Interesting statistics. So basically, the country code were 8% up, this overall percentage. So you see here that the generic of the remains, of course, the majority, but the country code are there. The country code are raising, so there's hope for it. Maybe if you loosen up a little bit the requirements, you get more registration. The trend of new generic domains is still very thin, but who knows? But it's probably supposed to be growing in the future, as we will see. Country code versus generic. This is an overall statistics. You see .com by far be the largest. Tokelau, and you may wonder why on earth Tokelau, which is a small island in the middle of nowhere in an ocean, does have the second country code registration number. Any guess? Because it's free. That helps. So anyone can get a .tk, Tokelau, but Germany, which is not free, has got third place with over 6 million registration. Next is a fourth place generic. China, fifth place with a country code Tokelau name. UK 6th, or another generic 7th. Russian 8th. The Netherlands, a bit surprising because it's not free and it's a small country. The 9th, and info is 10th. Most popular country code Tokelau remains as of March 2015. This is the most famous Tokelau, Germany, Brazil, and these are the top 10. So the top 10 is Tokelau, Germany, China, United Kingdom, Russia, Netherlands, Europe, which is .eu, as you know, Brazil, Australia, and France. That's the current statistics, yes.
Very recently, China just surpassed
Germany. These are the actual slides provided by the WIPO.
Yeah, that was very signed latest report.
So there was a disclaimer, and an apology because I didn't perhaps update it, but they're pretty much close. So the China was going over Germany.
Yeah.
Now, China is an important country.
And .tv is not one of the...
.tv is not amongst the top 10. It's Tuvalu, as you know, another small island, but TV was often, and it is often used for television-related websites. So in 2000 was the country code deployment program launched by WIPO, and as mentioned yesterday, 71 country code have retained the WIPO center as distribution provider, overall with some variation. And the country code programs cover registration, practice and design, web protection mechanism, and a WIPO best practice for all the country code policy, which are, again, aimed mainly to curb abuse and bad faith registration of protected name. Minimum standards for IP protection in the country code top-level domains were therefore introduced. What else? January 2000, this is overall statistics, 3,500 country code cases were held. Again, the top one was in 2011, similar to the generic one. And the top 5 countries for the procedures are the Netherlands, again, much our surprise, Australia, Colombia, Spain, and Mexico. Colombia. That's why. The Netherlands, I don't understand why, honestly. It's small, rather small country, but it's popular, but they're very litigious probably because they file other cases. And this is overall statistics. You have a database available containing links to 250 country code top-level domains, so Egypt is as well there. You find information about both the countries which have not adopted the UDP and as well the ones which have adopted the UDP. And it can assist practitioner to determine the applicable registration agreement or the service applicable. It's a very good database available free of charge online on the WIPO website, wipo.org. I'm not advertising WIPO, honestly. I'm working with them, so I have to disclose it, but they really are efficient. They dedicate a lot of stuff to these matters. They invest. It's a pro bono they do. They don't gain. Actually, they are on the balance level even in this way, but they are very, very efficient and dedicated. Okay, WIPO finding resources are here as well. So as I mentioned, you can have information on the countries which have adopted the UDP or variation, and you find it as this website, WIPO AMC, but you simply search on the WIPO website and you find this kind of data. 43, as I mentioned yesterday, have adopted UDP as it is. Yeah, so the rules that we discussed yesterday and you dreamed about last night are applicable directly, verbatim, to these countries. And of course, the advantages are the following. Amongst the following, facilitated acceptance, no major changes to the register agreement, neutrality of the panelists, independent country code deployment registration and administration, and basically allow the country code deployment domain to outsource the decision. This is a message for you in particular, because if you have an issue with the handling, you have to create your own arbitration panel. In Italy, we have to establish these good resolution providers services to provide this system. WIPO is there since 1999, has experience, why not? And typically you get impartial and independent decision makers, like myself. Country code is, as opposed to generic one, can be combined. These are basically the statistics, some of the decisions rendered in a country code and in a generic deployment domains. As I mentioned, you can combine in the same procedure country code and generic deployment domains, provided that the respondent is the same and that the country has adopted the same rule. Yeah, so in these 43 countries, you can mix and match, basically, for .com, for info, for org, and adopt, whatever. Romania, Colombia, and Montenegro, wherever you. What about variations? As I mentioned again yesterday, but we do a revision. 24 countries have adopted variation of UDP, and they are the following. Main variations, well, the key advantages are the same, basically tailored to the specific needs of the countries. Balance of the parties' interest with predictability and fairness of the decision in light of the local procedure. Some of the differences are the following. Let's say you may require the trademark is registered in your country, right? Or you may require that even personal names and company names that we have seen yesterday, we have to focus on trademark for UDP, can be protected. So, for instance, in Australia, in Spain, in the Netherlands, you have personal names as well that you can claim as rights to ground your complaint. Infringement of the national IP laws in Switzerland and Brazil. And my favorite, the option for the or. So we don't have the conjunctive requirement in these countries, but in Australia, Brazil, Spain, and others, Iran, you have the or. So you don't have to demonstrate in those countries anymore that the domain name was registered and is being used in good faith, but either or. Of course, they're both, it does not hurt, but if you only have bad faith use, which is often the case, or you don't manage to prove the bad faith at the time of registration, theoretically, even because the trademark was not there, in those countries you can opt for UDP and win. Mediation element in some of the countries, like in Switzerland and Netherlands, you have a mediation, which is compulsory. You basically have a mediation phase, and you reach a decision. And if you reach a decision by this mediation phase, you don't even pay a fee. For instance, in UK, which is not for the UDP applicable, but has a special system whereby the respondent does not even have to pay something if the decision is rendered within the mediation process. UDP, the variation, well, the number of the nationality of the panelists, the single member or three-member panelists are these ones. Panelists who is a national of the country are familiar with the corresponding country code, Brazil, Spain, language, as well as procedures, Spain, Brazil, Mexico, and dispute resolution providers. These are additional variations that apply to the UDP adopted in some countries. For instance, in Spain, in Brazil, Mexico, you cannot do the decision but in that language, irrespective of the registration agreement, irrespective of where the parties are based, the decision should be rendered for a .ts in Spanish. Yeah, so some exceptions to the rule. Updated general information is basically the following. So we have information regarding the evolution of the Mediation Arbitration Center. You find this information on the website, at this website. And you have a dedicated email, arbiter.mail@wipo.int. If you have any questions, they do reply, so don't hesitate to come up to them and ask questions. They really are friendly and they tend to be efficient in their responses. WIPO experience as a resolution service provider. Overall, as I mentioned yesterday, there were some modifications of the rules. Now we do a bit of a recap of yesterday. The updates impact on the filing modalities, modus of pleading. There were some changes in the form to accommodate this different notification recall that you have to now to notify the complaint only at WIPO but not the respondent in order to avoid the cyber flight, right? And this interesting locking, which is very important to sort of crystallize the situation where it is, right? 30,000 cases were rendered to date. What experience as a service provider? So if you do work in this field, this is precious, right? You can basically search for anything there. You can get all the information you wish about all the prior cases, and this is very useful. You have this legal index. You can search for full text there. So even if you have a doubt on what to write on a case, you can go to this resource and get information. Because you get 30,000 decisions there available for you. And even though, and as mentioned yesterday, all the decisions are published online, public access to a large quantity of legal and other data are contained therein. And as I mentioned perhaps yesterday as well, we don't have the principle whereby that we're bound by the precedent. The starter, the cheeses that you have in the US does not apply to the UDP per se, right? But you should expect the system to work if you have the predictability. So if you file something with the given sets of facts, which were reflected in the decision in the past, you should expect to get the same outcome. Right? So this is very important for the system like this to work. Because if you would be randomly selecting a colleague of mine and giving a completely different reasoning of a very similar set of cases of facts, that would probably destroy the entire system, would not make the UAP work. And that's why we strive in our meetings on every year in Geneva to try to reach this consensus. So we talk about the issues that we have amongst us, we have a different interpretation. On some of them we can reach consensus, on some of them we don't, like the free speech I mentioned, but it's clear. So that's why when you have this kind of issues, you may think about having this three-member panel instead of having only one. The resources are fully accessible, and this is a very important tool. I mentioned it yesterday, we maybe go over a little bit now. You have this, I would say, precious document for people doing this kind of work, which is the WIPO Overview 2.0, and 3.0 is coming. So look for it in the news. But this is basically a document summarizing the decisions rendered by us, and that time was that this was done was collecting this 380 decision from over 100 people, different panelists, and sort of distilling, I would say, the most relevant issues. We'll see some examples of this. So this is a kind of question that you may wonder, and was one of the questions that was coming up yesterday. Does ownership of registered trademark to which the domain name is identical or confused or similar automatically satisfies the requirement under paragraph 4a, which is basically the requirements for having a registered trademark? Well, if you are puzzled by night and you cannot sleep, you go back to this document and find out there is a consensus view, and this is a consensus view. So generally, a complainant that owns a trademark satisfies the threshold of having this registration. The goods and services are not relevant, as opposed to what we said yesterday for the trademark. And for the purpose of the starting of the UDOP, the fact is registered even after is not relevant. Of course, this has a bearing on the following part, on the bad faith. But per se, if you have a trademark registration, is not a problem. Obviously, sometimes if you have a trademark registration only in some, well, for instance, in the US, you have this national state registration, which is object basically of no verification whatsoever, and everyone can register, even if it's a descriptive trademark. You recall one of the problems of the trademark registration of yesterday? The trademark should not be descriptive. It should not be descriptive of the services and products that is referring to. How many classes do we have of products and services? It was mentioned yesterday. You're disqualified.
12 or something.
So I'm taking bets again. 42. 12.
45.
45. Yes! You're the winner. You're the winner. You're the winner. So, okay, 45 classes, 35 of products, and the rest of services. This is irrelevant for UDOP. If you have a trademark in a different class, it does not matter. You recall? This is important. It's one of the pillars of the trademark. It doesn't matter. Obviously, sometimes the registration is not sufficient, in the US in particular, but in general, you have a trademark registration. Or, another question, what is the test for identifying computer similarity, and can the content of the website be relevant to determine this? It was actually the question that one of your colleagues was asking yesterday. Recall? And there you find the answer. So basically, it's a standing requirement. As I mentioned, it does not really need the test would be basically oral and comparison between trademarks domain name to determine likelihood of confusion. it is basically a straightforward visual and oral comparison. That's what I was looking for. Yeah, so that's what we need. The content is not relevant per se, as I mentioned yesterday, for establishing the confusing similarity. But, as also stated here, can be then relevant to establish bad faith. If the domain name is really used in a confusing manner, and to create confusion as to the sponsorship association, you recall that bad faith requirement, well, it's stated there, but for the purpose of identifying the confusing similarity, it's not relevant. Right? This is a usual recap of what we did yesterday. Does the complainant add UDP relevant trademark rights in a trademark that was registered on which the complainant has acquired unregistered rights after the domain name was registered? Maybe I should have this question and without the answer, because I would have been asking you the question, and so I should use as a technique at the next workshop. I'll just keep the answer and then get yes. But this, I will be too kind with you today. So I was basically simply keeping it like it is. So what about this? Well, the consensus view show that does not prevent finding of identical neutrality when the registration of a name before the complainant acquires a trademark. So if you have a trademark after, does not matter theoretically for this purpose. Yeah? Because again, it's a standard requirement. You have to prove you have a trademark registration. Of course, then you have problems in finding bad faith, but that's another issue. So for instance, is in here, what needs to be shown for the complainant to successfully assert common law or unregistered trademark rights? So you know that you can find the file UDP on the basis of a common law rights. Unregistered trademark rights. What is a common law right? It's written there. Basically, is a trademark right that you acquire through intense use. You don't have a trademark registration, but you have used this trademark a lot. You have billboards around, and you simply get a bad advisor. You don't get a very good advice that you can get from law firms doing this kind of work. Not telling you that it's important to have a trademark registration. It's important to have a piece of paper whereby you can tell the world, hey, as of this date, my trademark is registered. But if you didn't do that, you can still use the UDP as a tool to solve the system, provided that then you show us sufficient evidence on unregistered trademark. And this can be, of course, providing us a lot of evidence. Investment that you did online, investment that you did on billboards, investment that you did to have advertising on paper. I had one case in which the complainant was basing the entire complaint on about 1,200 leaflets like this. So it was given out in London in an unspecified day. That's, according to this complainant, was the unregistered trademark. This was not sufficient to prove that the respondent had actual knowledge of the trademark, or could have actual knowledge. Right? So you have to, if you go for the unregistered trademark, provide us sufficient evidence of your trademark rights, even though they are unregistered. What about this question? Can a reseller, distributor, or trademark goods or service have right to a legitimate interest in the domain name which contains such a trademark? Don't look at the answer. Can a distributor? That's another question. Workshop ask question. What about? In light of what we discussed yesterday, can a distributor have sufficient rights, in your view?
If the contract between them
Yeah.
give the
Brilliant. Yeah. So this is in essence the answer. If the respondent is not abusing this position of being a distributor, he can have a legitimate right to keep the domain name. So this is the consensus view. Normally, a reseller or distributor can be making a bona fide offering of goods, and thus have a legitimate interest in the domain name if its use meets certain requirements. These requirements normally include the actual offering of goods and services at issue, the use of the site to sell only the trademark goods, and the site's accurately, prominently disclosing the registration the resistant relationship with the trademark holder. The respondent must also not try to corner the market. This is an interesting definition coming out of this decision. If you have some issues with the respondent, which is a distributor, going with Okidata. So this is basically setting the rules. So if the distributor is selling as well other goods, is not disclaiming, not advertising the fact that he or she is an actual distributor of the product, then the legitimate interest is more shaky. Because on one hand, he or she does have the legitimate interest, but is abusing the trademark of the large corporation, maybe to sell his own stuff.
But
So, yes.
usually the distributor can get like a written paper or agreement from
Right.
the company that says that he's allowed to use the.
Absolutely. But in that case, it's without in place. Should
Yeah.
we not have in place, and this is the critical advice, if you're advising a client to allow a distributor to use your trademark as well online, which can often not respect the limits of distribution agreement. Because of course, if you start selling online, you can sell everywhere in the world. It's appropriate to tell him or her, don't do it. It's my right, you don't sell online via, and I don't authorize you to use my trademark as the domain name. Otherwise, you really risk to get a plethora of domain name registration, which are in good faith, which are registered by the distributor to promote its activity, maybe selling in countries in which he or she does not have a distribution agreement in place. So this is a general overall. But in principle, should you not have an agreement, he can still claim a legitimate right if he uses the domain name in a manner which is not cornering the market. It does not have registered all domain names in the world correspond to a trademark, and if he's disclosing or she disclosing prominently disclosing the registered relationship, right? So, and again, you see in this scheme you have some panel take a position, what's called private view, to be very difficult for a respondent to establish rights of legitimate interest where the respondent has no relevant trademark rights without the authority of the complainant as used the domain name. So, some part of the panel said, well, fine to have legitimate interest, but you don't have a trademark right. You maybe have a license for a trademark right. Your trademark license is not yours. So you see how complex the situation can get in a straightforward kind of world like a UDP is. And this is very helpful as a kind of guidance. Let's take another couple of questions and then we break for a good coffee that you must start needing in. And can bad faith be found if the dispute domain name was registered before the trademark was registered or before unregistered trademark rights were acquired? What's the question? What's the answer? Yeah. What is that? Yes? Everyone is convinced? Bad faith be found if the domain name was registered before the trademark was registered or before unregistered trademark rights were acquired. Although the trademark can form a base of UDP action under the first element, irrespective of its date, when a domain name is registered by the respondent before the complainant relied upon trademark rights as shown to have been first established, whether on a registered or unregistered basis, the registration of a domain name would not have been in bad faith, because of the registrant could not have contemplated the complainant's rights. That's the issue. You can file UDP, and you have to prove bad faith. If the trademark was not there for the problems of the conjuncture requirement, it's really rare. Though, you may have certain cases in which you can claim to have actual knowledge, even if you have not have any evidence of registration of the trademark. For instance, in the cases of merging of two banks, classic case, in Intesa Sanpaolo, that major bank in Italy merged some years ago. And it was all over the news much before the in-house lawyers of the two banks managed to get together and have their both different agents to decide who is going to file this trademark registration for Intesa Sanpaolo. In that case, and the domain name being registered for Intesa Sanpaolo whatever, the bad faith could have been there, even though the trademark was not there, because the respondent could have had actual knowledge. And this goes into the path of having a real fact-intense case. UDFV is based on the facts, and the ability of the lawyers is to present the facts in the most, let's say, organized way and manner for having you to prevail in the UDFV. But as you see here, there's an however already provided here, and there was exactly the example of the merger already announced.
Or if, for
Yes.
example, he had the trademark not registered, but he can prove that under common law, this trademark belongs.
Correct. If you have common law rights, it's fine.
Yeah.
But that's as well a quasi-trademark registration. But the problem here is when the trademark was registered was not there. With the main the trademark was not there. So this is really an exception to the rule. And the general rule is stated there. It has to be registered before. And as you see, it goes on with respect to trademark registered before trademark, but I don't want to bother too much. We take one last question. Can multiple complaints bring a single consolidated complaint against the respondent? Can a single consolidated complaint be brought against multiple respondents? And the answer is, I mentioned yesterday, I expect you to know. Then I was not effective enough. Damn it. Anyway, it is possible. It is possible. Because you have to basically to prove the nexus amongst the same respondent. Right? So if you, even if the name of the respondents are different, but you establish same address, the same DNS, the same email, and this is kind of issues which will help you to consolidate the procedure into one single procedure. And now, as it is time for coffee, we break now and we come back in whatever time, 30 minutes, to the final presentation on the actual on cases.